Hello,
Hello to everyone.
Hello.
hello,
Hi.
Luca, you hear us?
Yes, very well.
Okay, thank you very much. Thank you.
Are we already streaming?
Not yet. I've just
Not yet.
confirmed. Hello.
All right.
We are waiting just for Anna Beatriz, who is going to set the live
Usually,
streaming.
basically, this event is like you can share the link so that there is some
Yes.
friend they want to share attend this event.
We have
You can-
a YouTube live streaming, and
Okay. Can you share the link?
sure.
I have already sent by email, but I'm just sending
Yeah, in
right
the chat,
away
in
here.
the chat, yes,
Yeah,
in the chat.
it's there.
And we have already shared this to our networks. We are supposed to start in 10 minutes, right?
Yes.
Yes, so we have 10 minutes to check that everything. Like I hear a little bit of background noise when I speak.
I
Oh,
think
now it's over.
I think it's Anna who has joined us.
Okay.
Probably she using another account, or maybe one of the tech guys, Giovanni, João, Nyasha.
Perfect. Now the sound is perfectly clear. So we are ready to start in 9 minutes.
Should we all just do a mic test? Can you hear me clearly?
Yes.
Okay, thanks.
Luca, what is the so first sequence of questions? So you first introduce the panelist and then the
Yeah,
sequence?
I think Felipe, do you want to review the
Yes.
agenda? Yeah.
So I'll be the moderator. So we'll start by a few opening remarks, and then we will have to move to Dr. Melody's questions, because unfortunately she will have to leave earlier. Then we'll move to Dr. Sayed's question, then Dr. Smriti, and then finally Dr. Lucas' question.
Okay.
Only no doctor for Smriti.
Not yet. Not yet.
Not yet.
Inshallah. You will get soon.
Yes. Yes. And for my second question, I wanted to share a little bit of evidence of my a couple of slides of my interaction with ChatGPT. Can I just test 1 second if it is working? I think yes. If I share it, can you all see?
It is still loading, but probably in a minute.
Does it work?
Not yet.
Now it's freezing everything for me.
Try to do it again. Cancel it and open again.
I'm stopping. Let me just. Close a couple of programs here. All right. So let me try again. Now it should work.
Yes. Yes.
Fantastic.
Is Anna with us in the room?
Anna just entered here in my office. Du bom? All right, so I think we are almost ready to go, and we are almost ready to live stream. Let me just check if the YouTube link that I've shared is the correct one, because I think that we have been sharing the channel of the CyberBRICS we have.
I think we have two different YouTube links.
Okay, at least one will work.
Yeah, there's one working. There's one working.
Yeah, I know.
And we are already live.
Okay, perfect. So we will then.
Let me put here the right link.
All right.
Wow, this one, we are live.
All right.
We are also right link.
We are live. Right.
This one, we are live.
Yes, on the channel, I guess, on the channel, and on the other link. All right. I think we can go.
Yes,
we are also we are live. Right.
This one, we are live.
Yes, on the channel, I guess, on the channel, and shall we start?
All set? Can we start? So, good evening for those who are watching us live in Brussels. Good afternoon for those who are in Brazil. My name is Felipe Medon. I'm a professor at FGV Rio Law, researcher at its Center for Technology and Society, and I was also a member of the Brazilian Federal Senate's Commission of Experts in charge of drafting the National AI Bill. I'm deeply honored to take part in this unique event, being surrounded, even if virtually, by so many experts. Our panel will try to bring the concerns of the countries of the rising voices of the G20 with regards to AI and data protection. That is in the core of the discussions around the globe, and notably in Brazil, where we have several efforts that are being made in the National Congress to regulate AI. Besides, this is also a key issue to the Brazilian temporary presidency of the G20. We'll try to bring as much as possible the highlights from these countries. And we take this opportunity to invite you all to the CPDP LATAM conference, which we are hosting next July in Rio de Janeiro at FGV Rio Law. With regard to our panel, we must say that the rapid growth of generative artificial intelligence is posing currently numerous challenges to data protections legislations and to their enforcement in the rising voices of the G20 countries, which include members of the BRICS plus grouping of countries as well. Despite providing significant advances, these technologies also present enormous risks. Regarding data protection, there are several concerns, notably about the training of large language models, which still remains unsolved. We aim to address normative initiatives regarding regulation of AI, focusing also on the current responses that are being given by data protection authorities around the world, and exploring challenges from the perspective of the rising voices of the G20 countries. To achieve this goal, we have put together 4 experts on these subjects who will bring us their different perspectives. Our panelists will address the ongoing regulatory efforts of the grouping, including the Brazilian AI bill, the Indian approach to data governance and digital public infrastructure, the African Union approach to AI, and the emergence of Saudi Arabia and the Gulf countries as key AI players. I'd like to express my gratitude to each panelist who has accepted our invitation to participate in this session, hoping that we can continue this conversation beyond these Zoom links borders. With that being said, we should move to our first round of questions. We'll start with Dr. Melody Musoni, because unfortunately she has an appointment and will have to leave us earlier. So, Dr. Melody Musoni is Digital Policy Officer at the European Center for Development Policy Management. She's also a former data protection advisor at the Southern African Development Community Secretariat. So, Dr. Melody, I'd like to start this by asking you our first question. Which kind of initiatives and policies in the African Union is the African Union adopting to frame AI in its intersection with data protection?
Thank you so much, Professor Felipe. Good afternoon or good morning, everyone who is joining our panel discussion. Thank you for that question. I think when we are talking about AI and data protection in Africa, our starting point should always be the legal instruments that we have in place. So for those who are not familiar with the regulatory or policy framework in Africa, at the moment, we have a convention called the African Union Convention on Cybersecurity and Protection of Personal Data, but most people refer to it as the Malabo Convention. So this is an important convention that we have at a continental level, which basically covers 3 issues. The first chapter covers electronic transactions. The second chapter covers protection of personal data. And the third chapter covers cybersecurity. And the chapter that focuses on personal data protection can, in a way, actually help us in regulating AI and especially where personal data is being processed. So you see when you go through the chapter, it lays out the basic requirements or principles that data controllers or data processors have to comply with when they are processing personal data. So I would say, in a way, that in itself, when you're using AI systems or AI tools to process personal data, you are required in terms of the Malabo Convention to comply with the law. That being said, the Malabo Convention, unlike other data protection laws that we have, it doesn't necessarily have specific provisions that cover issues like automated decision making or online profiling. And that in itself is a gap that we have in our convention. And the convention itself, just to give a bit of a background to those who are not familiar with the framework, it was introduced in 2014 and it only came into operation last year in June. So already there have been a lot of technological changes and advancements which require and make it necessary to update the convention. So what is the African Union currently doing? As far as I know, they are actually working on modernizing the Malabo Convention, from the interactions I've had with other experts, I understand that at the moment there is an ongoing project to actually update the Malabo Convention. As far as what the future of Malabo Convention looks like, we are not yet sure whether it's going to be an additional protocol to the convention or the convention itself is going to be updated, and then we have maybe a form of a Malabo 2.0. But what is important for us is definitely to see specific provisions on AI and processing of personal data and issues around data AI principles and how they can be applied when processing personal data. So that is what's happening from a personal data perspective. And then from an AI perspective, there is also a lot of developments in the policy space. Just this year alone, two initiatives or two instruments have actually came out from the African Union. So the first quarter of the year, I think sometime in end of Feb or early March, one of the AU agencies called NEPAD actually released a white paper on responsible AI. And that document itself was actually important in outlining or setting the scene of what the needs for Africa are and what the priorities for Africa are. And when you go through the white paper itself, you also see references to the need to protect personal data where AI systems are being used. And the document itself keeps also referencing the Malabo Convention, that member states need to adopt ratify the Malabo Convention. Not only that, at national level, member states need to also adopt data protection laws to regulate how personal data is being processed, including regulation of AI. And then recently, this second quarter, the AU also published or released a draft continental AI strategy. And if I can just go through, like, the vision for the AI strategy itself is that it's Africa-centric, responsible and ethical AI that empowers people and contributes to the continent inclusive growth, resilience, and socio-economic development. So this is a very new strategy. I'm yet to go through the document itself, but I understand that this is the important framework that the continent needs. And again, there is emphasis in the strategy for the protection of personal data, and member states are also being encouraged to adopt data protection laws and to update their data protection laws so as to ensure that personal data is being protected adequately, even where AI systems are being used. So I think I can pause there and wait for the next question. Thank you.
Thank you so much. My next question would be in terms of, with that experience of the convention and the notion of an African-centric regulation that you have just mentioned, do you think that the African Union can help us create an alternative to global north narratives instead of simply adapting a framework that has not been created with the so-called global south countries in mind?
Thank you for that question. I think in principle, yes, it's actually possible for the AU to come with a global south offer on what AI governance would look like. And I think the AU is actually doing the best it can at the moment to actually situate itself or to position itself in a place or at a place where it is able to have its own important principles to guide the discussions around AI governance. And for me, I think the continental strategy itself is a good starting point where we are beginning to see clearly what an African approach to AI governance looks like. So when you go through the continental strategy, it sets out guiding principles on AI that are guiding the strategy and that are supposed to guide the continent going forward. So if I can quickly just list the 8 principles that are set out in the strategy. The first one is local first. So it's something that you hardly see in other frameworks. For Africa, that is a priority for us. And what does that mean? It means that we want to AI and to use AI to actually address our own African challenges and our own problems. So it's the extension of that made in Africa for Africa by Africans principle that is being expanded in the strategy. Then it's also promoting a people-centered approach, which is how can we use AI to actually promote inclusive growth? How can we promote sustainable development, well-being, and cultural renaissance? And the third guiding principle is, of course, on human rights and human dignity. So in the white paper itself, I think it was one of the issues that we had highlighted, that the white paper was not very clear on what Africa's position was on human rights. And I'm happy to actually see that human rights is being, and human dignity and protection of human rights is being advocated for as a guiding principle for the continent. And the other guiding principle is on peace and prosperity, inclusion and diversity, ethics, cooperation and integration, skills development, public awareness, and education. So when you, of course, look at these principles, they are actually reflecting some of Africa's priorities. But of course, the question of whether this is enough to say this is an African approach or an African offering to AI governance is a different story. And I think we need more analysts to actually critically examine what the other offers are and how and to what extent the strategy and the guiding principles in the strategy actually differ. But for me, just the principle on local first, I don't really see it in other instruments. And I think that is one of the offers that Africa is actually proposing and articulating. And so apart from the governance perspective, I also think that at the moment, the African Union is strategically positioned to be in a way to influence global AI governance processes. So if we look at from the UN perspective, for example, there are ongoing conversations around development of guiding principles again on AI. And I think there is a report that was published sometime in December with a list of policy recommendations developed by the UN advisory body on AI. And a lot of those policy recommendations actually can support African countries, but still there's an opportunity for the AU and African countries to actually contribute and comment on the report itself. So by the time we go to the Summit of the Future, we will have an African offer and an African perspective or input to that global framework. So apart from the UN process, I would say another strategic point of entry for Africa, especially the AU, to engage in global AI governance is definitely through the G20. I think as a new member of the G20 and the G20 having these AI principles that it adopted, of course, copying from the OECD AI principles, there is also an opportunity for the continent to also contribute to these discussions, because as far as I understand and as far as I know, there are discussions to update these principles. So that is another way in which, as a continent, we can contribute and shape the future of global AI governance. And of course, I think most of us here are representing the BRICS countries one way or the other. So that's also another entry point for Africa to contribute. And looking at the G20 presidency, last year it was India, this year Brazil, next year South Africa. So what are we doing as the global South to actually advocate for our interests when it comes to global AI governance. And the same thing can be asked within the BRICS Plus context to say, what are member states actually doing to contribute to the discussions around AI governance? I don't know if Dr. Syed would talk a bit about the draft AI charter that was developed by the Islamic world, where 20 African countries are involved. That is a good initiative, and we need to see more of those engagements and frameworks coming from Africa to actually shape the narrative around AI governance. And I would say perhaps the other way would definitely be the G7. So it's something that I recently came across where the G7 has also made the announcement that they want to partner with Africa to start working on AI and sustainable development. So those are different areas in which, as a continent, we can influence the direction in which AI governance discussions and policy discussions are taking. And at the same time, we are able to actually present or offer an African approach to AI governance or a global South approach to AI governance. Thank you. I think that helps.
Thank you so much, Dr. Melody, for your amazing contribution to our debate, which they have helped us understand the African Union's approach and the importance of building our own tools to solve our own problems. It's also great to see that human rights is also the top priority of the AIU's approach, and how this interaction with the G20 and the BRICS Plus countries can bring benefits to its members. So thank you once again. Now let's move to Dr. Syed's questions. Dr. Syed Iftikhar Shah leads the Digital Research Lab at the DCO, the Digital Cooperation Organization. Dr. Syed, our first question would be the following. Could you elaborate on generative AI and the data protection challenges as discussed in the Digital Cooperation Organization's article titled Generative AI Reshaping the Digital Economy? Our team is already sending the link through the YouTube channel.
Thank you, my moderator, for asking these important questions. First, I describe about the Digital Cooperation Organization. DCO, a global multilateral body that aims to enable digital prosperity for all, accelerating the inclusive growth of digital economy. DCO 16 member states account for a combined population of more than 800 million people with a collective GDP of more than USD 2 trillion. The DCO brings together governments, the private sector, international organizations, NGOs, and civil society to enable more inclusive digital transformation and promote the use of emerging technologies, including AI, for the growth of global digital economy. The emerging technologies, including AI, are at the heart of DCO agenda. Therefore, DCO is performing information provider and advocacy roles to promote the adoption of responsible AI in every sector of life in the countries of the world, including the DCO member states. Now I come back to my dear moderator question about the DCO white paper on Gen AI. In this DCO white paper, we explain generative AI, an area of AI mentioning various Gen AI tools, including ChatGPT, and their roles to increase global digital economy. We also highlight applications of generative AI in public sector for efficient public service delivery, dissemination of effective, accurate, reliable, and complete information, and its application in decision support system to aid the policymaker and civil society to gather, analyze, and take strategic action to boost the global digital economy. We also describe the application for Gen AI in private sector for the following various activities: customer engagement and support, making a market research and development, language translation, scalability, and cost effectiveness to attract the and retain the customer to generate revenue that is a key to build a sustainable digital economy. The DCO white paper discussed Gen AI models and digital economy. Using Gen AI models, multiple segments of digital economy, including smart agriculture, digital industry, digital construction, e-healthcare, e-education, e-commerce, and smart transportation, either in public or private sector, can improve in several ways. We explain Numerous Gen AI challenges, including ethical challenges that create hindrance to enhance digital economies, such as consumer trust deficit, accountability, transparency, increased copyright violations, non-availability of complete and quality data, sharing personal data, propose the risk of sensitive information being extracted, unfairness and bias in Gen AI training data, lack of accuracy and security of personal data, and Gen AI tools inadequately comply with the data protection regulations. Now I'm specifically sharing with you a few AI governance and data protection challenges that we highlighted in our paper. Sharing personal data with generative AI tools pose risk of extracting sensitive information and amplifying exposure, potentially leading to privacy breaches, invasive advertising, phishing, scamming, and even identity theft. Unfair and bias in generative AI training data is a key challenge that is essential to achieve equitable and unbiased outcome, especially regarding the sensitive attributes like race, genders, and socioeconomic status. Crucial for uploading ethical standards in AI application, rephrase it. Another challenge is accuracy of personal data processed by the Gen AI tools is a fundamental data protection issue with such technologies. Lack of security of generated data through Gen AI tools poses data security threats like adversarial attack toward targeting generative AI models on generated data itself and aggregation and decrease people trust on Gen AI tools. Ensuring Gen AI tools comply with data protection regulations such as GDPR, HIPAA, CCPA during the synthetic data generation and usage, it is vital to prevent legal consequences and protect individual privacy rights. I hope I answered these questions.
Thank you so much. Our second question would be the following. Could you provide us insight into the AI governance approaches on a global scale, focusing specifically on the DCO member states of the Digital Cooperation Organization, and try to discuss the current initiatives that are being undertaken by the DCO in this domain?
Thank you once again for raising these important questions. As we know, worldwide, there are two schools of thoughts have emerged in the space of AI governance. Number one, principle-based approach, and second, a prospective regulatory framework-based approach. Now, I give a brief about these two schools of thoughts. Principle-based approach. This approach is adopted by US, Singapore, and OECD. A few examples of such principles include transparency, explainability, and accountability, proposing to boost an ecosystem where Gen AI-based tools can be developed and deployed in a safe, secure, and fair manner. The second school of thought is a prospective regulatory framework-based approach, which is adopted by EU and China. This approach is a conventional perspective and ex-ante regulatory framework approach with strict enforcement measures centered on a risk-based regulatory measures of Gen AI tools according to their potential harm. It is pertinent to mention that principle-based approach provides flexibility and adaptability. The prospective regulatory approach offers clarity and enforceability. Hence, there is a essence for finding the right balance between these approaches is crucial to effectively govern AI by promoting innovation and ensuring ethical, legal, and security safeguard through implementing soft regulatory norms. It is pertinent to mention that DCO member states are adopting hybrid approaches to tackle AI governance. I want to share a few DCO member states' AI governance approaches. Saudi Arabia, like the National Strategy for Data and AI, is ambitiously aiming to position the kingdom among the top 15 countries in AI development. The strategy is focusing heavily on skills, investment, and regulation, while also emphasizing the importance of partnership and entrepreneurship to grow the AI ecosystem. Most recently, in January 2024, the Saudi Data and AI Authority, SADAYA, launched guidelines on generative AI to promote the responsible development and use of Gen AI through principles capacity building, and appropriate regulations. In Jordan, the Artificial Intelligence Strategy and Implementation Plan 2023 to 2027 aim to implement the country AI policy from 2020. The strategy approaches aim from an economic and social impact perspective, focusing on AI contribution to upskilling, education, scientific research, industry, productivity, and future research. Pakistan, Ministry of Information Technology, Government of Pakistan is in the process of consultation to finalize the AI policy. This policy will be a vital milestone for transforming Pakistan into a knowledge-based economy, and it spell out a national strategy to establish an ecosystem necessary for the adoption of by harnessing an agile framework for addressing different aspects of unique user journey, encompassing different market horizontals and industry vertical by ensuring responsible use of AI. Greece and Cyprus, they are also the member state of DCO, and they are also EU member states. These two DCO member states are adhering EU AI Act that is focused on risk-based regulatory framework. Lastly, in Qatar, the national AI strategy follows a similar approach to the strategies of Jordan and Saudi Arabia, in the sense that AI plays a vital role in diversifying the economy with a significant focus on upskilling, future work, and economic growth. Now I'm sharing with you the DCO current initiative that focus to manage the AI governance and data protection challenges as I explained earlier. AI Toolkit, Responsible AI Tool, and Digital Space Accelerator. DCO AI Toolkit, the DCO is developing an AI toolkit, a suite of practice-based artifacts to support the DCO member state and the global community assesses their readiness to adapt AI at national level and define or refine the AI project charters. The AI toolkit is also in alignment with the pillars of Riyadh AI Call for Action Declaration signed and adopted by the DCO member state. The next initiative is DCO Responsible AI Tool. In this initiative, DCO is working on developing a responsible AI tool which can be used to help take ethics and human rights risk into consideration during the development, deployment, and use of AI across the DCO member states. DCO Space Accelerator is a thematic working group of thought leaders, subject matter experts, and decision makers from around the world, from government, businesses, international organizations, academia, and civil society. The accelerator builds and drives a network that advocates for cooperation among multi-stakeholders to design and propose AI solutions that address the key identified challenges on emerging area, including AI to enable human-centric, sustainable, safe, and inclusive digital economy. I hope I answered your question. Thank you for asking this question.
Thank you so much, Dr. Syed. Being mindful of our time, I would leave your last question to our final round so we can move on. And I would like to thank you once again for your amazing remarks, which have definitely helped us understand more about the DCO member state approach, their challenges, and recent developments, notably considering the emergence of generative AI. The right balance, as you mentioned, between the principle-based approach and a more detail-oriented piece of legislation, of hard law, is something that we are also discussing in Brazil. So I think that is a very important topic for all of us, to find the right balance between the model of legislation, of regulation that we are looking for. So we would move now to our next panelist. We would move to Smriti Parshira from our CyberBRICS project. Thanking her once again so much for being here with us. And my first question would be, what is India's current regulatory sentiment towards AI and automated data processing, particularly in light of the new data protection law approved in India?
Thanks so much, Felipe, and hello to everyone who's joined us online. So, there has been a lot of emphasis on promoting AI in India. So the policy environment has been much more around the question of, how do you encourage, how do you build, as you said in your introductory remarks there, India has been very bullish on digital public infrastructure. And part of the approach has been about how do you extend that thinking now to the field of AI, of cloud computing, creating data pools. So that's been really the policy focus. Come on the general approach to it. On the regulatory side of it, there has been less of a development, although we've seen some action in recent months. So on the question of the Data Protection Act that you talked about, that's something that India adopted in August last year. It's yet to come into effect, probably in the second half of this year. That should happen. And the scope of this law is that it applies to any kind of data that's held specifically in a digital form. And the definition of processing under the law talks about wholly or partially automated operations. So in that sense, all of the law applies to automated data processing, but unlike something like the GDPR, you don't have specific restrictions of any sort or a right against automated processing. So that's something which, doesn't exist in the Indian data protection law. In fact, to the contrary, one may argue that, the nature of the law is such that there is an encouragement, going back to my initial point about the emphasis on promoting AI, creating data pools is something both of personal and non-personal data, which is something which is being encouraged. And there is a policy push towards architectures and frameworks which allow for more data to be created, and which is also reflected in one of the provisions of the Act, which say that, if there is a piece of information voluntarily put out by an individual in the public domain, then that's not governed by the, framework of this law. So something which I may post on social media would be outside the protections given under this law. In some ways, kind of fueling that idea of having more data available and making it readily available for AI processing. But there is news from the government of there being a companion legislation to the data protection law, which is being called the Digital India Act. And that's going to be a holistic overhaul of the information technology regulation in India, which will include, as per what the government has said, rights against automated decision making. But the draft of this law is not yet in the public domain. So, we don't really know what it will, how this right will shape up and whether it will be there in the final draft as it emerges for consultation. But that's really broadly the connection between data protection and AI. And the broader question of regulation of AI, again, the general position has been that, since we want to encourage AI adoption, we are not looking to legislate at this point of time, but there do seem to be some deviations in recent times. So, India is going through elections right now, and elections, as all over the world, lead to these questions of misinformation and the use of, AI, generative AI in that misinformation process. And triggered by some of those concerns, there was an advisory issued by the government in March. And the first version of that advisory was really harsh, which basically said that if there is under-tested or unreliable AI models being used, then you need prior government approval for issuing those models. And you can imagine there was significant backlash from civil society, industry, everyone about this kind of an intrusive approach into something which is an emerging tech. And therefore, later in that month, there was a toned down version which kind of said that you don't have to take prior government approval, but you need to label any such unreliable or untested AI, which again remain vague terms because you don't know what unreliable AI means. But the current advisories, and just to note that this is an advisory, it's not a regulation or a law in that sense. So the binding effect or even the validity of this remains kind of in the gray area. But the position is that you need to label, the use of such synthetic media and be able to kind of identify which intermediary this was placed on and who was the individual who generated it.
That is definitely something important, especially when you consider the elections that are about to come around the globe. So India has been facing some, raising some questions in this sense. So it is also a very important question. And with that in mind, even with that background of elections, how is transparency in AI systems framed in the Indian level? Maybe that's something interesting to comment also.
Sure. Yeah, I think that's an interesting issue. And part of it, as I just mentioned, has been reflected in that AI advisory, because from a government approval stance, its toned down version is basically about transparency and labeling. But even beyond that, as I said, we don't have a law in India, but there is something called the Strategy on Responsible AI, which is released by the government's official think tank in 2021, and it kind of lays out, like these national AI documents usually do, a set of principles, transparency being one of them. And the way it frames transparency is linking it to the question of scrutiny and audit. So it says the design and functioning of AI systems should be such that it's available for external audit and open for external audit. And I think that's the case with many transparency principles, where it's linked to explainability or auditability in some sense. And actually, I want to just draw in some thoughts from a IGF a dynamic coalition paper, which was edited by Luca and Walter last year, where I talked about looking at the question of transparency in the Indian context. That was in the specific context of one project, which is called Digi Yatra. It's a project for enabling automated boarding using facial recognition at airports. But the broader question on transparency there was that I observed that in most of these contexts, when we think about transparency in the AI context, we are usually talking about technical transparency. So it's about what data is being used, how does the code work, what goes in, what comes out. So the technical aspects are what get a lot of attention, and rightly so. But there's also like two other layers, right? There is a policy level transparency where we need to ask questions about how did this intervention come about? What is the legal sanctity? Is it based in a law? Was it a consultative process? And then there is an operational level transparency where you need to know what's happening on a day-to-day basis, like what is the organizational structure of the entity where such projects are being based, who are they accountable to, is there public accountability, are they accountable under things like a right to information framework? So those are the kind of questions, and in that particular case, I found the framework lacking on several of these rounds. So I'll stop with that. Thanks.
Thank you so much, Smriti, for bringing us so many interesting topics to our conversation, and for highlighting the Indians' most relevant experience in this intersection between AI and data protection. You've also helped us understand how we can adapt existing frameworks, notably when it comes to digital public infrastructure, and how can we take advantage of what is already there for AI now. In Brazil, we've been discussing, probably Luca will speak a little bit about this next. We've been discussing how will which body will be the AI office in Brazil? Who will be that body in charge of enforcing the law here in Brazil? And there's a huge pressure for our DPA, our Data Protection Authority, to be that body. And that raises us a lot of interesting questions. So with that in mind, with that bridge to Luca's questions in mind, I'd like to now move to Luca Belli's question. Dr. Luca Belli, our head of the Center for Technology and Society at FGV Rio Law. And Luca, I would start by asking you, how is AI framed in the Brazilian Data Protection Bill?
I think we have a lot of interesting ideas emerging in the current Brazilian scenario, and I think it's good to try to connect them to two, let's say, scenarios, overlapping scenarios, an internal one and an international one. We have currently in Congress, at the Brazilian Congress level, at least 15 bills dedicated to AI. One major bill, Bill 2338, that has been recently updated after a specific commission of the Senate tried to restructure it and reformulate it. But yet again, this is not final. This Bill 2338 is the most complete, let's say, the best structured. We have a lot of other bills in Congress. All of them are simply bills, so we do not know which will be the final one to be voted. We know that the Congress wants to vote by July, so in a couple of months maximum of delay, because then there will be elections at the municipal level, and so Congress will be, most of the congressmen and congresswomen will be focused on this. And so if nothing is voted until July this year, it's highly likely that nothing will be voted until next year. Now, at the same time, we also have Brazil as having their rotating presidency of the G20. and AI being one of the main topics of the G20 this year. And at the same time, we also have AI, or well, to better say, automated processing of personal data as already regulated in a very explicit way by the existing data protection law, the LGPD, the General Law for Data Protection of Brazil. That is the Brazilian version of GDPR, as many of you already know, that was adopted in 2018, entered in force between 2020 and 2021, and already has very explicit provisions for the automated processing of personal data, and also general provisions that, of course, they apply horizontally to any kind of processing, including automated processing by AI systems. And also, they apply with an extraterritorial scope. So any type of company offering services to Brazilians or targeting Brazilians must comply with this law, right? So it has a global reach, if you want. And so all the provisions already in terms of purpose limitation, data quality, adequacy, transparency, accountability, and a key provision is also non-discrimination. They already apply. Why I'm stressing non-discrimination? Because this is a sort of peculiarity. The explicit principle of non-discrimination is a sort of peculiarity of the Brazilian framework that to some extent makes life particularly difficult for AI systems. Because if you think, for instance, about profiling is all about discrimination. I'm not speaking here about discrimination in terms of discriminating people for their gender, race, but I'm speaking about creating categories of people and taking different decisions based on the category. AI profiling is all about that, right? So the prohibition of discrimination becomes very difficult to reconcile with a development of AI systems based on the processing of personal data. And there are a couple of provisions that are specially targeted at AI that are already in force. Article 20 of LGPD creates a right for the data subject to have a review of any kind of decision, automated decision, based on the automated processing of their personal data that can affect any kind of interest of the data subject. So this is much wider than GDPR, for instance. So it's really about any type of processing, automated processing that affects any type of interest. And of course, the law, Article 20, already includes profiling as an example. It is not limited to profiling, but it includes also profiling. And to this right to review also corresponds an obligation of the controller to provide adequate information, clear and adequate information about the criteria and the procedures that are utilized for the processing. This is very tricky. And actually, this is a point I really want to stress, because it really then gives us an idea of what is called the law in action and law in the books. If we speak about the law in the books, so the provision, we think that is wonderful. We have already a right to review, and then we have already an obligation to provide clear and adequate information about how the decision is taken. But then if we go to the law in action, we see that it's not well specified if the review has to be done by the human or can be automated. So for the data science, it's already quite tricky. And then there is this adequate, this adjective that is, together with reasonable, is probably one of the favorite adjectives of lawyers, because it means basically anything. So the right to have, the obligation, to provide clear and adequate information may mean anything. So as long as this is, as what is adequate information about the criteria and procedures of the automated processing, as long as this is not specified by the regulator, it's an empty provision, because if you are in good faith and you develop AI processing data, personal data, you don't know how to comply to this. You don't know what is adequate information you should provide to the subject. And if you are in bad faith, you think that anything could be adequate, and you simply don't care about complying with the law because anything is adequate.
Thank you so much for your first answer. I would like to stress something that you mentioned about the automated decision making, it is regulated by our LGPD. But as you mentioned, it fails to adequately deal with the problems that you have mentioned. For instance, as you pointed out, we don't have an explicit right to human review of that automated decisions. So actually, to be more specific, we had this in an explicit way, but it was under a veto from the then president Jair Bolsonaro. So we had this in the law. It was even praised outside Brazil for its ability to make a difference between the different scales of impact that an automated decision could have. So it wouldn't be a general right to human review, but only in certain cases. So, for instance, small and medium enterprises would perhaps be would fall into an exemption from this provision. So that is something that is also important. So that leads me to the next question for you, which is the existing regulation effective? I think you've already brought something of that, but how is the Brazilian Data Protection Authority responding in the implementation of the law? I know that you've had a couple of things to share with us about this interaction with the Data Protection Authority, and I'd like to give you the floor.
Yeah, I think again, I think that when we have to discuss regulatory strategies, we have to consider the effectiveness of them, right? So I think we all agree that laws and authorities are needed, especially with issues that present such high risks like data processing, AI systems. But then it's important to design systems that de facto will be effective in practice and will be implemented, right? And also to think about how to do it, right? The kind of resources, be both in terms of financial resources, but also in terms of intellectual resources, which kind of human power is needed to implement then the law correctly, right? And I think that the recent experience in terms of data protection in Brazil, so how a developing country integrates a model, a law, a kind of thinking about data protection that is inspired from European model and OECD, but it's adapted in a way that does not really become naturally so effective, because of course there are different levels of maturity between Brazil and or any other developing country and Europe, right? So it's very important to think about these details when designing a system. And we're not only speaking about data protection. Data protection is a good case study to then understand how we should regulate AI, right? And so let me just come back to what I was mentioning before, the fact that if there are there must be in the laws some provisions, some objectives that leave the law flexible enough to not to give an exhaustive list of which kind of specific provision can be specific tools, specific examples can be considered as adequate or reasonable, but precisely leave it open so that evolution can happen naturally, is not hindered by specific provisions that could be over specific, too detailed. But then at the same time, if we want to have this flexibility in the law, we must match it with a regulator that knows how to implement the law and does it and makes life easier for those who have to build the system or those who have right and want to enjoy the right. So the case of Article 20 is very interesting because it gives to every Brazilian a right to know, not only to have the review, but to request the developer of the system and the controller of the data processing to give them insight on how the decision was taken. So last year, I did a nice experiment to understand to what extent this right was actually existing in practice. Let me just quickly share a very interesting piece of evidence. So when I started to ask ChatGPT last year information about Luca Belli, ChatGPT started to give me a lot of interesting information that were partly my personal data and partly what are called hallucinations. So interpretation of my personal data, right? So for instance, it started to give me several bullet points about what I was doing, mixing personal data with fanciful information. When I asked this, you see, where does Luca Belli live? It replied me that I live in Sao Paulo, where I direct the Center for Technology and Society at the University of Sao Paulo. But that is only partly correct, because I live in Rio and I direct the Center for Technology and Society at FGV Rio. So it's a mix of real personal data with hallucination, right? What are called hallucination. And so I inquired and I asked ChatGPT, how did you find this information? And ChatGPT confessed. So it told me that actually it is a language processing. It uses language processing capability to analyze my query and generate a response based on the relevant information available in its database. So it confessed it had my information, my personal data, in its database. And then it also kept on going, saying that I drew my training data and searched my database. My database must be in its database for information about Luca Belli's background, accomplishment, and contributions. So again, all in personal information. When then I asked, then I was asking this both in Portuguese and in English. Then when I asked how did it find this personal information, again he started saying that was not personal information, was information available online. Then I replied, no, that is indeed personal information. Then at some point I started understanding that I was arguing with a bot, with an AI system. It is not healthy to do so. So I decided to stop there, and I tried to check what was ChatGPT data protection, OpenAI data protection privacy policy, actually. So let me just share it as well, because it's very interesting. I've checked last week, and it's still the same. So this is the privacy policy of ChatGPT or of OpenAI in Brazil. It does not exist. It's error 404. And why? Because there is no personal privacy policy in Portuguese. It's only in English. And actually, it was interesting because then I was interested. I looked if there was any other language available for the privacy policy, and there is no other language than English. But of course, it is available for a plethora of other countries that are not English speakers. And so when we then go back to the Brazilian legislation, and particularly Article 9, that gives also to every Brazilian the right to access to adequate and clear information about data processing, it was evident that all this, at least the bare minimum of adequacy of information, was not existing, because there were not even a privacy policy in Portuguese. So I petitioned the regulator. But then to my surprise, the regulator, some weeks after, a couple of months after, actually, they replied to me, dismissing my petition and saying that basically ChatGPT or OpenAI, by giving me access to my personal data as a user of ChatGPT, not my personal data to use to train the model, were more than enough. I think this is a very peculiar interpretation of the law, because the law does not mention in any point that data protection provision only apply to the service provision and not the training. The training of AI system is data processing, of course. And I even had prints of the ChatGPT's confession saying that actually it was training its system using my personal data available in its database. So I think, again, my point here is to say that we really have to be careful by analyzing, first, by understanding that adopting the law and creating a nice authority is only very much the first step of the regulatory journey. The most difficult part comes with the implementation. And secondly, understanding that we need to be flexible to encourage innovation and not to block innovation with over burdensome obligations. But then, if we do so, we need to be able to specify how these flexible obligations are implementable in practice. Otherwise, it will be simply impossible for good faith developers to build their own system in compliance with the law. And for bad faith developers, it's very easy to simply disconsider the law.
Thank you so much, Luca, for your answers. Thank you so much for bringing us such an amazing overview of the Brazilian framework and for your approach based on concrete examples. We all hope that you find a solution to your case. That is something that really intrigues us all. So we have around 15 minutes. So I would like to ask each one of you one last question, hoping that we all keep track of our time, so we can end our panel just in time. So I'd like to get back to Dr. Syed's question, the third question, which would be the Digital Economy Trends report launched by the Digital Cooperation Organization during January 2024 World Economic Forum event. This report highlights key trends, notably in generative AI, and provides implications and recommendations for policymakers, the private sector, IOs, NGOs, to tackle AI governance and data protection challenges. So could you share with us these aspects per the DCO Trends report?
Thank you, Philip, for asking this question. First, I describe the DCO Digital Trend Report, which envisioned to serve as a one-stop shop, a comprehensive resource of insight on the digital economy. The report provides access to vital information and facilitate informed decision-making within the digital landscape. The report provides an outlook on digital economy themes, trends, supporting enablers, and implications, and associated recommendation action for the stakeholders to boost a sustainable, safe, and human-centric digital economy. The report consists of various key themes, including AI. We highlight 3 trends against each theme. For example, AI theme consists of 3 trends: Gen AI for the cutting-edge software development, AI-powered digital government, and accelerating environmental sustainability through Gen AI. We uncovered the driving forces, i.e. digital economy enablers, behind the identified trends. For example, for the trend theme AI, the key enablers include upskilling talents and promoting human-machine cooperation, laying solid digital foundation, and AI governance. As per today's event topic, we also mentioned the AI, including Gen AI applications and related recommendations for the public and private sector and IOs, NGOs. For example, for the private sector implications, public sector organizations are facing the challenge of AI governance framework that support technological advancements such as AI and ensure adequate balance between innovation, ethical, and social economic concerns. Recommendation: the public sector should partner with relevant private sector stakeholders and others to create a governance framework centered on responsible yet innovative development of AI. These adaptable framework would allow for the rapid experimentation with clear accountability and liability measures, fostering innovation with a controlled environment. Additionally, the public sector should invest in training programs to equip government personnel with the knowledge needed for effectively govern these evolving technologies. For the private sector implications, companies should diligently adopt to evolve AI governance requirements and compliance framework as per regional and global best practices on AI technologies. Recommendation: the private sector should actively collaborate with public sectors and contribute to shaping AI policies and governance framework, leveraging industry expertise to foster governance that strike a balance between fostering innovation and safeguarding economic and social well-being. Additionally, ensure adherence to evolving governance requirements, fostering a culture of compliance and transparency across all aspects of operation, particularly within the algorithm development. For the IO and NGOs, the implication: there is a need for global cooperation among IGOs, IOs, NGOs, and relevant private sector organizations to ensure a cohesive approach regarding AI governance. Recommendations: IOs, IGOs should encourage active involvement in international forums dedicated to AI, cultivating and promoting partnership and collaboration between international entities, academia, industry experts, and diverse organizations to achieve convergence on global governance standards for AI technologies. I stop here. I hope I answered your question. Thank you very much.
Thank you so much, Dr. Syed. Moving now to Smriti's last question. What strategies can regulators and stakeholders adopt to promote the development of AI without jeopardizing fundamental rights? What could we learn from the Indian experience in that field?
Yeah, thanks for that. I think there is this important fundamental question about what should be the role of the government or, of the state when we're talking about promoting the development of AI, right? And the Indian path, as we discussed earlier, has pretty much been where the government is trying to play a very hands-on role, where it's trying to create this ecosystem, develop infrastructures, and be very hands-on involved. Just yesterday, we had this news report which says that the government has now decided that it's going to fund the support, a foundational AI model, which will be kind of a government-backed one and a government-supported one. And there are fundamental questions to be asked about, is this the apt role for a government to play, or should it just create a playground within which this can happen, but not really actively play the role itself? But given what we have in terms of the situation, I think some principles and some of them are not really being followed in the way adoption is taking place in India would be, firstly, the idea of there not being any coercion in the adoption of any of these systems, right? So the system I talked about earlier, DigiYatra, about boarding at facial recognition based boarding, that's a system which is a good example, because on paper it's a voluntary mechanism, but the way it has translated into practice is that it has become a very coercive mechanism where, either gates are not being reserved for people who want to opt out of the system, or the officials who are handling this at the entry point are kind of forcing you to consent. So in terms of, the actual interaction of the individual and the system leads to a situation where there's no effective, consent. The second idea, I think, would be about participatory models. So participatory both in terms of the policy process and decision making, but also in terms of how the databases are developed. And there is a good example. So India has a lot of diversity of languages, right? So, and last, one of the things we're seeing is that there is a lot of emphasis on kind of developing language models which are suited to local languages, right? So if you have, the ability to use chatbots or translation in languages which are outside of English, outside of the 22 official languages, the hundreds of other languages that we have in India. And there, one of the government projects is something called Project Bhashini, which is a crowdsourcing initiative where people can contribute, through their own voice or by verifying the text or audio put by others to verify and kind of build this language model. And that's an example of a infrastructure which I think, because it's based on voluntary participation, is a good way to build a participative AI model. Finally, I talked a little bit about this earlier. It's the question of accountability. I think that's an important question which needs to be part of the regulatory strategy when thinking about any kind of AI adoption. So it cannot be limited to just pushing for promotion, without thinking about the, how do you bring about transparency and accountability in the process.
Thank you so much. The diversity of languages is a true problem. But even inside one country, usually when we are talking about big countries, like large countries like Brazil, India, we have different variations of legislation inside the own country. So even if we're speaking the same language, we still have minor adjustments to make in certain cases that could really be something for us to think about. Our last question would be for Professor Luca. And the question is, how can we implement the upcoming AI framework, considering its intersections with data protection existing legislation? And besides that, how can we at the same time stimulate AI development? Because fostering innovation is also one of the key concerns in this background.
Yeah, thank you very much for this question. Actually, this brings me to do two considerations that we have been voicing in several publications and even in public hearings when the Bill 2338 was in his elaboration phase with public consultation. And really, I think it's key here to understand that that is what we call AI sovereignty in the works that we are doing here. It's impossible to only regulate AI and not develop AI if you want to be sovereign. So if you want to be sovereign in the sense that you are able to understand, develop, and regulate AI, you have to put resources in studying how the AI works to be able to then develop it. And then, of course, you have to regulate it according to your own values, right? Your own referentials. And I think that I think that the problem of the current Brazilian approach and of many other countries, including European Union, is which is not a country but a collection of countries, but is to think that regulation by itself is sufficient to be able to assert sovereignty and to steer the evolution of AI. It's necessary. Regulation is necessary, but it's not sufficient. You also have to be able to develop AI, right? And this is something that I think the government, the federal government, has understood very well. The legislator so far has not. So we have these two different approaches. In Congress, we have multiple bills about how to regulate AI, but the government is rebuilding the AI strategy of Brazil to be able to foster the development of AI. But it's quite interesting to understand, to see that actually the federal government understands quite well the fact that there are risks, but also a lot of opportunities. But if you want to reap the opportunities, you have to invest money and to have a strategy, right? A plan. Actually, in this moment in the federal government, there is an effort to elaborate both a strategy and a plan with concrete actions to develop AI. And at the same time, then you have to calculate that there are risks, and that is where the risk-based regulation comes very useful. And then to implement it, you need to have a very skilled and very well-resourced regulator or regulators. Another point that we stressed in our contributions during the public hearings is the fact that given the multiple dimensions of applicability of AI, concentrating regulation of AI into a unique regulator, it's a very high gamble on the capability of such a regulator. Creating a new one in Brazil would be very difficult. Again, the data protection experience leads us to think that a new regulator takes years to be built and other years to start to work, precisely because it is very difficult to build a new entity and to staff it and to have well-resourced and well-trained individuals working there. So that the approach that is now put forward by the legislator is to use the DPA, the Data Protection Authority, ANP, this is called ANPD, the Autoridades Nacional de Proteção de Dados, the National Authority for Data Protection, and to delegate to the Data Protection Authority the main task of implementing the law and coordinating a system of other authorities, which is something to some extent, again, we were advocating for since our contribution in the public consultation, in the public hearing, stressing that the need for multiple types of expertise can be either solved with a new super regulator, very difficult to build, or by creating a system of public authorities that have already competence and remit to analyze specific issues and then cooperate amongst each other. This is also a very risky gamble because it has never been experimented in practice in Brazil. And so it's actually currently the latest proposal that has been tabled by the latest version of Bill 2238, but we still have to see how this will evolve and how this will be voted in Congress. And then we will have to see if in practice this will really work or not.
Thank you so much, Luca. Now, unfortunately, we are heading to our closing remarks. I'm sure we haven't been able to bring all the answers, but I definitely hope that we have asked the right questions in our panel. I'd like to thank each and every one of you who are watching us live and will watch us later. Thank our dear panelists for the amazing insights that they have brought us, for their effort for being here with us, and thank CPDP's organization for our strong partnership. We all look forward to receiving you all in CPDP Latam in Rio de Janeiro at FGV Rio Law next July. So thank you all once again, and we'll see each other soon. Bye-bye.
Bye-bye. Thank you. Thank you.
Bye-bye.